Everybody loves AB5 is the favorite topic to call and discuss with us. The ABC test, which determines whether your independent contractor is actually an employee. The original law which stemmed from a California Supreme Court case, had a number of exemptions that were very industry and occupation specific. This new AB 2257 kind of adds more exceptions. There's quite a few of them, but primary ones are recording artists and related occupations, photographers in certain situations, really a lot of occupations related to sound recordings and musical compositions. I guess the entertainment industry, very happy with AB 2257. Certain insurance occupations, including underwriters, real estate appraisers, and home inspectors. There is a very complicated revision to the criteria related to when there's referral agencies, whether they apply to AB5. And then there's a new exemption for business-to-business relationships between two or more sole proprietors. Really very technical and advanced, probably too much to get into now, but keep in mind there are these new changes to everybody's favorite law.
SB 1384 allows the labor commissioner now to represent people that don't have the financial means to hire an attorney further in the process of trying to collect unpaid wages. So got a lot of comments about this, but I'll keep them to myself for now about this bill. But basically, it's allowing the labor commissioner to proceed and continue to represent the employee if there's been a motion to compel arbitration. And again, I want to talk about the arbitration agreements here shortly. In California, the California courts and the legislature do not like arbitration agreements in the workplace, and they've done everything that they can to limit those arbitration agreements. Employers have been able to use arbitration agreements under federal law. Federal law has put some teeth into these agreements in the context of employment, in the employment context here in California. And for large employers, I think the arbitration agreements are something that every employer should be looking at and using. If you're a smaller employer, you've got to think about it, but there are some great benefits. The primary benefit with some arbitration agreements is that it moves these claims from public court into a private arbitration proceeding. They're more efficient, and as well, the employers can oftentimes have a waiver, class action waiver in those arbitration agreements as well, so the employee can only bring the claim on behalf of himself or herself. So we're seeing this where the labor commissioner now is able to fight the motion to compel arbitration by the employer and be involved in that process under this bill. Quickly, I'll cover AB 1512. It applies to security officers. It allows employers to have security officers remain on call for a rest period. And this law basically has come out from a court decision a couple years ago that said the employer is not effectively relinquishing control over security guards if they have to still monitor a pager or a radio during their 10-minute rest break. This law, and it's particular to security officers, and there's certain registrations that have to apply for this exemption to apply to security officers. Outside of the security officer context, though, it's a good reminder for employers that for these 10-minute rest breaks, you need to release the employee of all control for that to be effective 10-minute rest break. You can't have them monitoring a telephone or a pager or subject to recall. So they need to be free to leave and do what they want for the 10 minutes.